What documents must be included in the marriage or legal cohabitation file to be submitted to the municipality, and how to proceed?
Although the Civil Code is not as specific regarding the documents required for legal cohabitation as it is for marriage, it is best to present an identical file in both cases. This file must contain 6 documents for the foreign partner of the couple. First document, a valid passport. Second document, a full birth certificate. Third document, a certificate of single marital status or divorce, or a copy of the divorce decree with a certificate of non-appeal. Fourth document, a certificate of nationality. Fifth document, a certificate of custom, which is in fact an extract from the applicable law in the country of origin. And sixth document, official proof of domicile or residence. If you are residing illegally, this will be the Annex 3, obtained after submitting your application for regularization of residence, which we discussed in the previous video. The birth certificate and the certificate of single marital status or divorce, or the divorce judgment accompanied by the certificate of non-appeal, must come from the country of origin and be authenticated by an apostille or legalization. They are valid for only 3 months and, if issued in a foreign language, they must also be translated into the official language or one of the official languages used in your municipality. As for the certificate of nationality and the certificate of custom, they may come from your country's consulate or embassy in Belgium. For the spouse or partner residing in Belgium, no document is normally required, but it is advisable to provide a copy of the birth certificate to speed up the procedure. On the very day your file is submitted, provided it is complete, the municipality is legally obliged to immediately issue an acknowledgement of receipt. However, in practice, most municipalities do not hand over this document, claiming they first need to carry out an address check, conduct an investigation, or contact the immigration office, which usually results in an order to leave the territory. All these excuses are false. There is no legal reason to refuse to issue the acknowledgement of receipt. I insist that this acknowledgement of receipt is essential for 2 main reasons. First, it prevents any expulsion from the country until the end of the procedure. Second, it triggers the legal deadlines. Maximum 1 month for verifying civil status documents and draw up a marriage declaration, 2 to 5 months, maximum for an unions of convenience investigation, depending on whether the opinion of the public prosecutor is requested. If you do not have this acknowledgement of receipt, you cannot prove when the legal deadline started or when they end. This allows all sorts of abuses, and I am often consulted by couples whose files are blocked for many months, sometimes over a year, simply because no acknowledgement of receipt was issued. The municipality then claims that no file was never submitted, that no concrete steps were even taken by the partners, or that there was only a vague request for information. In short, if you do not receive an acknowledgement of receipt on the day you submit your file, it is essential that you immediately contact a lawyer, specialized not only in immigration law in general, but especially in family reunification matters.